Mwamuye to seek contempt orders as against the respondents in petition E396 of 2024. That's ground number 1. Bahati Mwamuye to institute contempt proceedings as against the respondents in petition E396 of 2024. Number 2 is that the respondents have violated the rights of the intended accused persons. Number 3 is that the respondents have violated a number of provisions of the Constitution of Kenya 2010. And number four, before I get to the final number 5, number 4 is that the charges are bad because they are defective. And finally, number 5, for compassionate reasons because the first accused person just lost his heart. On the basis of those grounds, Learned Senior Counsel Dr. Haminwa has asked you, 1, to be courageous, and number 2, to make history by rejecting the charges. Now, Your Honor, that's our understanding of the dispute from the defense side, the basis for which they want either rejection or a deferment or a throwing into the bin of the charges before you. However, any court, including this court, can only do what it is empowered to do. And my starting point is the jurisdiction of this court. This court can be courageous, can be bold, but only within its jurisdiction. The criminal jurisdiction of this court is provided for under Section 6 of the Magistrates Courts Act 2015. Sorry, Your Honor, just before I go to that, it's trite law that jurisdiction is everything. I need not quote the authorities, but one of those is Samuel Kamau Macharia versus Kenya Commercial Bank and another. And of course, the time-tested honors of Dr. Vessel S. On the basis of those two authorities, the criminal jurisdiction of this court is provided for under Section 6 of the Magistrates Courts Act 2015. But there's also an important aspect of your jurisdiction under that act, provided for under Section 8 of the Magistrates Courts Act 2015. And that jurisdiction is the jurisdiction to enforce constitutional rights and fundamental freedoms. Section 6 of the Criminal Procedure Code gives you powers to hear and determine criminal charges as the intended ones on the basis of the subject charge or charge sheet, as delineated by the Criminal Procedure Code, as the CPC, or any other written law, including the Penal Code, or any other written law, including the statute, the basis of the charges before you in both the charge sheets. The court will have an opportunity to have a look. So that is Section 6. Now let's go to Section 8 of the Magistrates Courts Act, that this court has powers to enforce rights and fundamental freedoms limited to Article 25A and B of the Constitution. Article 25A and B only of the Constitution. The first concession we make at this point, subject to further medical examination, is that whatever. Sorry.
Repeat that, huh?
At what point, Your Honor?
Yes, just repeat that. The right to enforce fundamental rights and freedoms.
And limited to Article 25, sub-article A, and Article 25, sub-article B only. That is express letter of the law. And Your Honor, I was moving into a concession from our end that whatever order this court will make must then allow the second intended accused person to be taken for medical checkup. We have no reason to doubt Counsel Willis Otieno that there are injuries, but that should be determined and medical attention be given upon examination. Whatever order this court finally gives, that is on the basis of Article 25A, because the court has those powers. To that extent, Your Honor, the charges before you are properly before you, before we get to their propriety, the substance of the charges. The DPP, in the exercise of its powers under Article 157, subarticle 6A, that is 157, subarticle 6, subarticle small a, to bring charges and information before you, before this court and the High Court respectively, to institute criminal proceedings against any person criminal proceedings against any person before any court. The two suspects are any person, they fall within the definition of any person. Before any court, this court is, except in the case of a court martial, which we are not. So procedurally, the DPP is mandated and was entitled to present these charges before you. That then takes us to the substance of the charges before you. But Your Honor, just before I get to the substance, allow me to address a number of issues which we think are outside your jurisdiction and which, despite your attempts to be courageous and or bold, you cannot get into. That this court cannot enforce constitutional rights and fundamental freedoms outside Article 25A and B. For example, a mention has been made as to the improper or irrational cancellation of a certificate of firearms, contrary to the provisions of Article 47. This court cannot look into that, however bold and courageous. That is outside Article 25A and B. So it means the court must shut its eyes to Article 47. This is not to say that this court is exempt from the provisions of Article 10 of the Constitution on the national values and principles of governance. This court is bound, but from a holistic interpretation of Article 10 vis-a-vis judicial authority under Article 159, vis-a-vis the powers of the DPP under Article 157(6)(a.
Yeah, I'm trying to get you and record it.
I'm sorry, Your Honor. I have a problem with my tongue.
The court is bound, is indeed bound by Article 10, vis-a-vis?
Vis-a-vis judicial authority under Article 159. Vis-a-vis the prosecutorial powers of the DPP under Article 157(6)(a, together with Section 6 and Section 8 of the Magistrates Courts Act. that a holistic interpretation of thereof reminds this court that a number of actions you've been asked to do are within the province of the High Court under Article 165, sub-Article 3. Sub-Article 3. In other words, the jurisdiction to determine whether an act or omission alleged to have been done under the Constitution is in violation with the Constitution belongs to the High Court and not this court. If the arrest of Honorable Wanjigi and all the second accused person violated the Constitution, or rather, whether or not the arrest, whether there were 50 police officers, and we don't take it very lightly, those statements, whether there were 200 police officers, and therefore the action of the police were in violation of the Constitution, that determination can only be done by the High Court under Article 165, sub-Article 3. And this is not to say that the police should get scot-free where there are, established violations of the Constitution. And the Constitution has provided for the means to deal with that, including the establishment of the Independent Policing Oversight Authority, with a mandate to investigate such allegations and to punish or recommend for prosecution such police officers. So that, Your Honor, personally, I am very sorry, very sympathetic about the issues raised against the police, and which I have no reason to doubt. But that this court has no jurisdiction to make a determination thereof. And without jurisdiction, you down your pen on that issue. Your Honor, are the police in contempt of the orders of the Honorable Bahati Mwamuye? Again, this court has no jurisdiction to enforce unless the orders are directed to the court to reject charges. The court that issued the orders is the proper court to enforce its strength of violation, if at all, of its orders. Your Honor, if police robbed the family of Honorable Wanjigi, again, this court cannot make that determination. But luckily, Your Honor, as Chief Justice Emeritus Willie Mutunga said, there is no violation of the Constitution that has no remedy. A remedy lies, and it does not mean that if this court, in exercise of jurisdiction, limits its entertaining of the issues raised, that the accused persons or their advocates in that case, who are also violated, will have nowhere to go. They actually have the High Court to go to, and they have gone to the High Court. In a sense, therefore, Your Honor, still on the question of jurisdiction, what is before you is very limited. And that takes me to the substance of the charges. Does this court have power to reject charges before it? Yes, we agree easily with the defense. But we disagree on the basis they are inviting you to reject the charges. And from a criminal law perspective, this court can only reject charges in the following cases. Where the particulars of the charge do not or are not in consonance with where the evidence is not in consonance with the charges or the particulars, or the particulars are not in consonance with the statement of the charge. You know, that power is granted under Section 89, subsection 5 of the Criminal Procedure Code. 89, subsection 5 of the Criminal Procedure Code, that this court can reject charges on that basis. You can also reject charges where the charges are bad for duplicity, or they are rather duplex. There is no allegation before you that these charges are duplex. So that a charge may not be defective as proposed by the defense for the reason that the actions leading to the charge were in violation of the Constitution. I am awed to be in the presence of very senior counsel this morning. I am comparatively younger in the profession. But I would appreciate if I am shown any authority.
No, we are trying inherent power to the court.
Thank you for that reminder. This is what
They record you in brackets.
That brings me back to that question of jurisdiction. Allow me to just read a quote from the now retired criminal law guru, Justice Bononga. And this is what he said in respect of what you've been invited to rely on as inherent jurisdiction. I'll quote, I didn't expect this to come up, but I'll provide a copy of this decision. The decision is Elijah Nyakebendo Onsongo. Elijah Nyakebendo, Nyakebondo, Nyakebondo, Elijah Nyakebondo Onsongo versus Republic, 2017 Kenya Law Reports. And this is what the learned judge said. First, a subordinate magisterial court, which is this court, including a court of senior principal magistrate, only has jurisdiction as may be conferred upon it by any statutory law, including the Constitution. In criminal matters, as in the instant application, such courts do not have inherent powers. It is important to point out that such courts only have inherent powers in civil matters in terms of Section 3A of the Civil Procedure Act. So that another thing as regards your jurisdiction is that you do not have inherent jurisdiction. Your jurisdiction is given by law only. The Constitution, the Magistrates Court Act, the Criminal Procedure Code, and the Penal Code in respect of criminal law. I shall provide a copy to the defense as well. You were asked and invited. Sorry.
So you're saying a criminal law, the jurisdiction
is only as provided by statutory law, including the Constitution. The court does not have inherent jurisdiction in our matters. Those are not my words. Those are the words of a person I call so highly, Justice Bononga. Therefore, this court has no powers to exercise judicial review authority over the decisions of the DPP. In fact, even in practice, it has never happened. The judicial review of the exercise of the mandate of the DPP under Article 157.6, as guided by Article 157.11, can only be exercised by the High Court under Article 165, which is the court that tests whether a law or an act under the Constitution is in contravention of the Constitution. So that while it's very flowery, this court cannot stay proceedings in a manner other than rejecting charges under Section 89, subsection 5 of the Criminal Procedure Code. And Your Honor, there is a test of the propriety of the substance of charges. That test is provided for under section 214 of the Criminal Procedure Code. I've just forgotten the word, so I may need to refer. Allow me. Oh, sorry, 134. Section 134 of the Criminal Procedure Code. This is the test as to the propriety of charges.
Under section
134 of the Criminal Procedure Code. This is what it says. Every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged. That section 134 tells you what a charge sheet, the charges in a charge sheet should look like. So that what this court would simply do is to look at our charge sheets and confirm if each of the charges has a statement of the offense and has particulars. Then go of the first and second accused. Your Honor, I exercise the powers of the DPP, the delegated powers of the DPP under Article 157. I swear it is not part of our work to detain or arrest. I swear. That power is granted to the National Police Service under Articles 243 to 245 of the Constitution.
that is the power to
The power to arrest, police power to investigate and arrest. Although under Article 157 sub-article 4, or is it 5, the DPP has powers to direct the Inspector General of the Police.
Commissioner, just trying to understand what happened because the orders are against the DCI, DPP, and the IG. So I just wanted to understand. He's trying to excuse the IG and the DCI.
No. I'm not excusing any of us. It's admitted from when I started that
do
the
I
DPP.
have a copy of the ruling?
Yes,
Yes, we passed on all the rulings to you.
The only thing you may not see is the parties, which I admit the
You're
DPP is.
referring to which petition? Which
This is E396. E396 of 2024. The one I have, you may not see the parties, but we admit that the Director of Public Prosecutions is the second respondent. What the DPP through me is telling the court is that we are not mandated to arrest and or detain anyone, the DPP. Related thereto, the DPP did not arrest nor detain anyone. However, the DPP has brought these charges before you this morning under Article 157, sub-article 6, sub-article A. You know, that distinction in the roles of the DPP and the police is very important. So that for the DPP to bring charges before you, even this court on its own motion, like some time back, could summon somebody before court on the basis probably, I could have an example of inquest proceedings. And the DPP would later charge that person without them having to be arrested or detained. So that our role in this court this morning is to look at the propriety of the form and substance of the charges. The question as to the arrest and or detention and or possible contempt of the orders of Honorable Bahati Mwamuye are matters that, as we have said, are out of your jurisdiction, and as we admit from the defense side, are live before Honorable Bahati Mwamuye. so that by the DPP charging the suspect before you is not in violation of any court order. The Director of Public Prosecution has not detained, has not arrested, has simply charged, and is therefore not in violation of any of the orders, whether prayer order number 1, 2, all the way, none of them. An argument can be made that the police possibly are in breach of the orders of the High Court. This court has no jurisdiction to consider that. That matter is live before Honorable Bahati Mwamuye. The parties will address those issues before the Honorable Bahati Mwamuye with respect. There is no effect on the exercise of the mandate of the DPP by any of the other respondents having violated, if at all, these orders. Because the DPP is not in contempt, if at all.
Don't forget the DPP is legal advisor. So the DPP is legal advisor on the criminal investigation.
Yeah, I'm almost done. There may arise, as a preemptive, there may arise the issue of the effect of a possible finding of violation or breach of the right of the orders of Honorable Bahati Mwamuye, because this has been raised before by counsel appearing before you. In Julius Kamau Mbogwa versus Republic, Julius Kamau Mbogwa versus Republic. This is criminal appeal number 50 of 2008, 50 of 2008. It is reported in the Kenya Law Reports in 2010. This is what the Court of Appeal had to say about the effect of violation of rights on criminal charges. The bench was made of a very powerful bench of judges, E.M. Githinji, P.N. Waki, and Anashir Visa. And this is what they said, in, if I may quote: the breach of a right to personal liberty of a suspect by police per se is merely a breach of a civil right, though constitutional in nature. Which is beyond the statutory duty of a criminal court, and which is compensatable by damages. That the Court of Appeal, which is binding on this court by the doctrine of stare decisis, has held that even where there may have been a violation of the right to personal liberty, as in the circumstances before you, even if this court were to have had jurisdiction on that issue, which we submit you don't, then the remedy would have been in damages and not a quashing of the charges. That law remains law, binding on this court. We are aware that the Honorable Justice Aburili has in Siaya, in Charles Odhiambo alias Ogis, delivered on 30th of January 2023, held that a violation of rights would lead to a quashing of charges. We humbly ask this court that you are bound by the Court of Appeal, and that court in Siaya is equally bound by the Court of Appeal. Stare decisis. In response, in summary, therefore, can this court reject charges? Yes, but not on the grounds provided. Is there a basis to reject charges? No. because the charges meet the provisions of Section 134 of the Criminal Procedure Code, which is the text. It also meets the requirements of Section 89 and therefore cannot be rejected under 89.5. Can this court stay the proceedings? No. That is the jurisdiction of the High Court under Article 165. For whatever reason, you can't stay proceedings. Can this court exercise inherent jurisdiction or what is called discretion? Not in criminal cases. This is a criminal case. Can this court throw the charges into a dustbin? There's no legal provision for that. As I conclude, if the defense intends that the Director of Public Prosecutions, as has been mentioned, reviews these charges, the DPP has to be moved. We are welcome to receive letters for possible review of the charges. We act independent of the police or National Police Service, and instructions from the DPP that we can receive applications from anyone, including the accused persons, for review of charges. I submit. Thank you.